Shift our focus now to the huge setback for the petitioners, including the victim's family, in the 2012 Delhi Chhawla Gangrape case. The Supreme Court has dismissed a review petition that has sought a review of the acquittal of 3 death row convicts in the case. Now, a bench comprising Chief Justice Chandrachud and Justices Ravindra Bhat and Bela Trivedi said there is no factual or legal error apparent on the face of record requiring review of the judgment that has been passed by the Supreme Court. The horrific Delhi Chhawla Gangrape case dates back to 2012 when a 19-year-old was allegedly gang raped by 3 men. The victim was brutally tortured by her attackers, even pouring acid into her eyes, and then she died 3 days after the crime. The trial court held the 3 men guilty, and later in 2014, the Delhi High Court had upheld the death sentence. But in November last year, the Supreme Court ordered their acquittal, citing that the prosecution had miserably failed to prove the case beyond reasonable doubt and also could not form a chain of circumstantial evidence. Let's go across to my colleague Harish Nair, who's joining us on the broadcast with the details. Harish, seen as a huge setback for the petitioners as well as, of course, the victims' family members. For a long time now, they've been waiting for justice, but the case was dismissed. What are the observations that were made by the Supreme Court?
Yes, so good morning, Pratibha. As you rightly put, a huge, big setback for the victim's family as the Supreme Court 3-judge bench led by the Chief Justice of India, Chandrachud, has dismissed the review plea filed not only by the victim's family but also Delhi Police, the MHA and the Centre and several NGOs like the Uttarakhand Bachao Manch, Uttarakhand Lok Manch and social activists like Yogita Bayana. Supreme Court 3-judge bench had on March 2nd heard the review petitions against the acquittal of 3 death row convicts. In fact, on November 7 last year by the bench led by then Chief Justice U. Lalit. So in the judgment, the review petition judgment, it is said that after having considered the judgment and other documents on record, we do not find any error, either factual or legal, apparent on the face of the record requiring review of the aforestated judgment passed by this court. And referring to the arrest of one of the convicts, Vinod, who was subsequently, after his release, arrested for murder on January 26, which was pointed out by the petitioners. Supreme Court said, even if an event which has no nexus to the instant case had taken place subsequent to the pronouncement of the judgment, that would not be a ground to entertain the review petitions. So it's a huge setback for the family of the victim, despite the Delhi Police, the Home Ministry, the Centre and several NGOs throwing their weight behind them and promising their support. Remember, setting free the 3 convicts, Supreme Court had remarked that the prosecution had miserably failed to prove the case beyond reasonable doubt and also could not form a chain of circumstantial evidence, which has now been upheld by the review bench.